understanding your child custody and parenting time options in divorce and decoupling. I'm Taylor Casper, owner and managing attorney of the Wins Law Firm, where we help women navigating divorce walk through the process with confidence so they can get everything they're entitled to and use it as they write the next chapter of their lives. It is super important to understand the distinctions and the legal terms when we're talking about child custody and parenting time. So there are three major things I want to discuss with you today as it relates to those topics and those issues. First, I want to help you understand and define what is legal custody, what is physical custody, and what are your options for parenting time. We'll start first with legal custody. That is one that I see misunderstood probably the most. So, legal custody is decisions about health, religious upbringing, and education. The presumption in the state of Minnesota is that two parents, if they're generally fit, meaning nobody's physically abusive, completely and totally just opted out of things, or doesn't have some other major deficit like severe mental illness or some other chemical dependency, something that would make it pretty impractical for them to make knowing, thoughtful decisions about health, religious upbringing, and education, then it's likely that you're going to be in a situation where you're going to have shared or joint legal custody of your minor child or children. Now, that can make things a little bit tough. I've talked at length with a number of my friends in the industry who are mediators, divorce coaches, therapists, and we see lots of situations where people have major, like headbutting, big disagreements about things that really are legal custody. Because they're legal custody, you have to understand that that means that both parents have the right to decide or to opt in on where a child goes to school. Both parents have a right to have an opinion on what type of medical care the child receives. Both parents are going to have a right to say what type of church the child should go to, whether they shouldn't go to church at all, whether they should go to mosque or go do nothing. Those are things that both parents are going to be able to weigh in on. And so there has to be some sort of framework or some sort of mode in place to decide what happens if we have disagreements about these things in the future. What are we going to do? How are we going to solve them? Are we going to go to mediation? Are we first going to try to schedule a phone call and talk to each other on the phone? Are we going to exchange ideas and proposals in writing via email? What are we going to do? Because when you're talking about, I know for me, I got divorced and my children were very little. If you're in my shoes and you have a baby when you get divorced, you might have 17 years of going through how do I make these decisions with the other person about various things that are going to come up. That can also be extended to things that aren't enumerated in the statute, because that's what's stated as health, religious upbringing, and education. But you're going to have other things that are going to come up that I would argue are kind of a part of legal custody, whether or not the kids play sports and do extracurriculars. When does a child get a cell phone or a car or things like that? These are the types of things that both parents really do have the ability to and should have the ability to weigh in on. There's a whole list of things too with legal custody, like a right of access to information. So if you're signing the child up for sports, adding the other parent, if you're taking the child to a health appointment, letting the other parent know in advance, collaborating on who should be the doctor, who should be the dentist, where are we going to get treated, what type of treatment are we going to receive. These aren't unilateral decisions when you share joint legal custody with another person. There's also something called physical custody. Legal custody is the big stuff, like these big decisions about how are we going to rear and raise a child. Physical custody, if I had to define it, is more boiled down to what we're doing on like the day to day. So physical custody is what do we do in my home with the child. So in my home, maybe we want to eat a gluten-free, low carb diet in my home, and that's how I feed my children. That's my prerogative when they're in my home, because I'm in charge of the day-to-day physical custody decisions when they're here. If they go to my co-parent's home and at my co-parent's home, they eat pasta every day, well, that's his prerogative in his home on his parenting time. We can have a difference in opinions on what we think is appropriate should do on a day-to-day basis with the children. And that's not violating anybody else's right with respect to physical custody just because we don't agree. So those are probably the two biggest differences. Health, religious upbringing, and education are your legal custody buckets. In Minnesota, you're probably going to share legal custody with your co-parent unless there's abuse, or if there's severe chemical dependency or something that would render it completely impractical to have joint legal custody. But physical custody, that day to day we see go several different ways. Some people use the physical custody label and they decide that the person who is the custodial parent, like the parent who has more than 50% of the parenting time, that parent might have sole physical custody. We see a lot of situations where people just drop the physical custody determination in its entirety because it doesn't mean as much as it used to in the past when more families had, dad honestly just having every other weekend and Tuesday night for dinner. So now that that's not the case, and we have a lot of parents who have 50-50 parenting time and a shared parenting split, either we're not even seeing the physical custody label used or parents just have joint physical custody. That one means, a lot less than it used to. Now we're more focused, I would say, on parenting time. Parenting time is actually where is the child on a day over day basis. There are several common parenting time arrangements. The most traditional old school parenting time arrangement is the kids live with mom and dad has the kids every other weekend and Tuesday night for dinner. Then we moved to in Minnesota a 25% presumption of parenting time for both parents. So instead of Tuesday for dinner, even if the children primarily live with one parent throughout the week, they're going to have one day during the week every week that's with the other parent, and that's how you get to 25% parenting time. So every other weekend, and then Tuesdays and overnight with a drop off of Wednesday at school. That's a common one where we have one parent who has more parenting time than the other parent. Now, in Minnesota, we've swung a lot in the last, however many years that I've practiced since I started in 2017, where we would see a lot more parents who did have unequal parenting time or a disparate balance in the time. Now, I would say we've seen a big push towards parents having more equal or shared parenting time in the state of Minnesota, what a lot of people like to call 50-50. So there are some common 50-50 arrangements that we see used more often than others. There is the 2-3-2, the 5-2-2-5, or a week on, week off. I say most commonly what I see is the 5-2-2-5, where, mom would have the kids overnight every Monday and Tuesday, dad would have them overnight every Wednesday and Thursday, and then the parents would alternate the weekends beginning at Friday and ending with drop off at school on Monday morning. And that's your typical 5-2-2-5. A week on, week off is another one that we see that's typically used with older children, though, because a week on, week off for somebody who's, say, 3, 4, 5 years old is a very long time to be away from any one parent, especially the parent maybe that they spent more time with prior to the divorce, decoupling, or separation. So 5-2-2-5 is a very common 50-50 split for younger children, and then the week on, week off for older children, we see a lot. They tend to stop wanting to do the back and forth during the school week and just like, I'll stay here all week, I'll go the next place the next week. And that seems to work just fine. Now, I love how people will hear this and they're like, this is what our family's doing, or how the court is very quick to put families into a 5-2-2-5 or a week on, week off. But even if you desire to have an equal or shared parenting time, duties, responsibilities, I think that you need to think really critically about what actually works for your family. Because for some families, it's not going to work to just blanketly say, this is your week, this is my week, or I have these days, you have those days, because as kids grow, mature, and get older, we see a lot more running back and forth for sports activities. Maybe the kids don't go to school in the district and they have to be driven somewhere. What if a child has a special need or a need that requires therapeutic treatment, day treatment, some sort of alternative schooling arrangement or situation? Then maybe that 5-2-2-5 doesn't quite work. What about when parents have non-traditional work schedules? Not everybody works 9 to 5. Some parents are school teachers, so they're off all summer, but then they work, really early in the morning during the week. Some people work second shift and their job is from 4 p.m. to midnight. Other people do 24 hours on call, for example, for our medical professionals or our firefighters, first responders, things like that. That 5225 might not work with that work schedule the way that it's intended. So for some people, the best thing that you can do is agree, we're going to share joint legal custody, we're going to share joint physical custody, and then we're going to create a parenting plan. So not per se a set, these are your days, these are my days, but more of here's how we're going to handle the business of running our family and raising our children and where they will be when. Those are the big ticket items I think that people must understand about child custody and parenting time before they walk into the divorce. So they're not confused by the vernacular. They understand what one thing means versus the other. And they don't have unrealistic expectations about how things are going to go in the divorce or decoupling process or child custody process if you were never married. A word to unmarried mothers: if you do decouple, and you were never married, the law says that you have sole legal and sole physical custody of your children until it is established by a court of competent jurisdiction. That means that up until the other party petitions and says, I want custody or I want parenting time, they aren't really awarded anything under law. So that is something to understand as well. Now, what that means in practicality, though, is different than what I think a lot of people think it means, because we do run into issues where we see people, women will or mothers will go out and try to get a passport and they can't get it because they don't have court paperwork or, you name it. I've seen a handful of things come up. So that is something to just think about and consider if that's you. Now, if you found value in this video, then make sure that you go ahead and give it a like and that you subscribe to this channel so that you can keep getting valuable content from me about everything divorce, decoupling, and co-parenting.